What is the rule of law? The rule of law is a principle that means that every person and body, whether public or private, and including the state, are subject to the law. This means that no one is above the law. The rule of law requires that laws should be publicly made, widely communicated, enforced equally, consistent with human rights, not retrospective, meaning they shouldn't go back and change the rules for events that have already happened and then hold people or bodies to account for those events now according to the new rules, and that any disputes about the law should be decided independently. The rule of law means that people can have certainty on what the law is, be able to access the law, and have accountability when the law may not have been followed. This includes accountability where the executive or government may have overstepped the mark. Courts play an important role in helping people seek justice and ensuring that the rule of law is applied. The rule of law and our Human Rights Act. Our Human Rights Act is an essential part of the rule of law in the UK. It brings rights home by taking 16 of the fundamental human rights in the European Convention on Human Rights and putting them into our law here in the UK. This means that individuals can challenge the government, including local government and public authorities, without having to go to the court in Strasbourg, France. The Human Rights Act puts legal duties on the state to respect, protect and fulfil our rights. This legal duty must be met at all times, especially during times of crisis. Our Human Rights Act helps to ensure accountability so that no one, including the government, is above the law. It is our Human Rights Act which says that the state must not treat us in an inhuman or degrading way, Article 3. That our private and family life, Article 8, our liberty, Article 5, and our right to be free from discrimination, Article 14, must be respected. It is important to note that while the rights come from the Convention, they are now applied here at home. It is the Human Rights Act, not the Convention, which creates the legal duties for people in the UK to hold government and public bodies to account. The courts also have an essential role due to the Human Rights Act. They must interpret laws as being compatible with the Human Rights Act, and if this cannot be done, they can make a declaration of incompatibility. However, this declaration does not change the law. Parliament is the one who decides whether to change laws to ensure that they are compatible with the European Convention on Human Rights.